Within a 2-week span, the Biden administration announced 2 new immigration policies. The first being a bit reminiscent of the Trump administration policy to keep some people out the United States. And the second was used for military family members to help keep some people in the United States. June 4th, 2024, the Biden administration announced a policy to suspend and limit entry at the southern border. This policy restricts asylum eligibility for those who are seeking to cross or have crossed the southern border without prior authorization since the policy went in place. This also includes unauthorized entry by sea. If an individual does not have authorization to enter and seek asylum at a port of entry, generally, they will not be eligible for asylum unless they can demonstrate exceptionally compelling circumstances. What are exceptionally compelling circumstances? Well, the policy states, if an individual can demonstrate that they face an acute medical emergency, or if they can demonstrate that they face an imminent extreme threat to life or safety, such as an imminent threat of rape, kidnapping, torture, or murder, or if the individual satisfy the definition of victim of severe form of trafficking in person. As you can see, the standard is heightened. If they are not able to demonstrate exceptionally compelling circumstances, they will be processed and deported quickly. If they manage to enter without inspection and they get picked up by ICE, they will be processed and removed, deported immediately. Those ordered removed will be subject to at least 5-year bar to re-entry and potential criminal prosecution. Having a criminal record can affect an individual from eligibility in receiving other immigration benefits, and being barred also affect an individual eligibility for other immigration benefits, such as if someone seeks to petition for that individual, they would have to wait until the bar is up. And as the policy states, the minimum is 5 years. It could be more depending on that individual particular circumstance. For instance, if they were caught entering before and they were deported before for entering without authorization. Additionally, under this rule, asylum seekers will not be referred for credible fear screening with an asylum officer unless they express a fear of return to their home country or a fear of persecution or torture or an intention to apply for asylum. So that individual that seeks to get asylum into the United States or to enter to apply for asylum in the United States have to first express that they are in fear or they seek to get asylum for them to be referred to for a credible fair hearing. They will not be automatically referred for a credible fair hearing. They would first have to express their fear as listed, a fear of returning to their home country, a fear of being persecuted, or their intention to apply for asylum in the United States. Asylum seekers are required. Now, this is the baseline of the rule. Asylum seekers are required to use the CBP-1 mobile app to schedule an appointment at a port of entry to seek asylum unless they can show that they have a compelling circumstances and it's exceptionally compelling circumstances. So the standard is heightened. So absent a exceptionally compelling circumstance, an individual must have an appointment to seek asylum at a port of entry. On June 18th, 2024, the Biden administration announced a new process to promote the unity and stability of families. This policy provides for beneficiaries who entered the United States without a valid visa and were not inspected at a port of entry, who are generally unable to obtain green cards through adjustment of status. They would typically have to leave the country and apply for their green card outside the United States. However, this recent policy changes that and now allow for these beneficiaries of a U.S. citizen spouse to apply for parole in place. So it added an additional process to the process for parole in place and then adjust their status while remaining in the United States. Each beneficiary is considered on a case-by-case basis, and that individual must demonstrate that they've been present in the United States without admission or parole for at least 10 years as of June 17, 2024. They also have to show that they are legally married to a U.S. citizen as of June 17, 2024, and they have no other disqualifying circumstances like disqualifying criminal history. Non-citizen children of potential requesters may also be considered for parole under the parole in place process for the parent. Their non-citizen children may also be able to apply for this process as well if they're physically present in the U.S., in the United States, without admission or parole. So they too have to show that they weren't inspected, they didn't enter on a visa, and they weren't given parole into the country, and that they have a qualifying stepchild relationship to a U.S. citizen as of June 17, 2024. If they're eligible, the parents and the children, if they have kids eligible, then they can stay. They wouldn't have to leave, as I mentioned earlier, and do the consular process outside the United States to obtain a green card, which is typically required. They can remain, apply for parole in place, and then apply for adjustment of status right here in the United States. Also, this new policy provides for DACA recipients and undocumented immigrants who have graduated from an accredited U.S. institution of higher education to obtain a non-immigrant visa that may provide a pathway to permanent residency and ultimately citizenship. Let's review the qualification for a U.S. citizen or green card holder to be able to lawfully petition for their non-U.S. citizen spouse. They have to be legally married. They have to domicile in the United States, meaning they have to be living in the United States or intend to return to the United States to live. And they also have to file what's called an affidavit of support, stating that they are financially able to support their spouse. And if they're not able to support their spouse based on their income, they would have to do a joint sponsorship with someone else who earns enough. Now, the way to show that you earn enough, you can either use your income, which you're gaining from employment or a business, or you can use assets. Thank you for watching. If you want more videos like this one, like, share, and comment.